Not currently. I don't have time to do it right now, but what days does your show tape?
Well, I'm live every morning at here in Chattanooga, and your time, you're in Central Tennessee, your time would be 8 to 10. And I'd like to get you on to ask about the claims made by Grenda Harmer, the prisoner, who says that an arrangement was made to have him possibly killed by a member of the Crips gang in the jail. In a letter to the commissioner.
Letter last night. So yeah, I'm looking into that, and I will email you back a response as soon as I have that completed.
Okay. Would you be able to come on the show to talk live as you're now live on the air? Could you come back and talk the substance of this claim?
Let me check my schedule for the rest of the week. I'm traveling part of the week, but let me check that and see if I can make that work.
All right. Well, I appreciate that very much. Thanks so much, Nisa.
Thank you. Bye-bye.
Bye. This is David Tulis, and we just are talking with Nisa Taylor, who is the spokeswoman for the Department of Correction. And I sent her last night, as she requested me to do, a copy. There were 4-page attachments to her by email of a letter sent to the commissioner of correction. That is to say, Commissioner Parker. The date of that letter is August the 22nd. And you, my listener here at Nooga Radio, have an early peek at that document, because it is a worthy report by a man who's an articulate prisoner. He's a felon, and he is been in contact with me to raise questions with the state's administration about the use of these prisons and the abuse in them of inmates such as himself. He has today at Nooganomics.com a story that I got from an earlier letter about the use of profanity. Now, it is a problem when you are in prison, that you not have the F word, the MF, the D, the S, any other words. There are numerous other epithets and curses that can come out of one's mouth. Of course, the use of God's name in vain, that's probably the most important one. Some scatological references, some words that refer to abusive use of sex. That, of course, is a very noted commonplace, right? That's used by tough men, right? Tough men use words like that to show how strong they are and how masculine they are and how they're in charge. And Grenda Harmer, who's prisoner number 88710, says that this kind of activity by Corporal J. York violates the rules. And he says that on July the 27th at about 7:10 a.m., Corporal York used profanity against him. Now, we have profanity used by the Chattanooga Police Department, and this is not apparently of concern to Chief Fred Fletcher when he got report of it. Now, that would be in the Hanson-Melvin case, and according to Hanson-Melvin's affidavit, David Campbell, the officer, said, ungrip your MFing hands, which were around his keys. And the officer had innocent man, Hanson Melvin, bent over the roof of a car, and he was patting him down, and Hanson had his house keys and his car keys in his hands, and David Campbell used the term MF to order him to unlock his hands and let the keys go. And so this is abusive. In my mind, that's a firing offense. Does city council accept that? Does city council accept that police officers such as David Campbell, who has since been fired, use the word MF to a member of the public, right? And the members of the public are all innocent. Every single one of them, even a gang member, should be understood to be innocent until he's been convicted. And here we have an abusive arrest, of course, subject of a lawsuit by probably the city's best attorney. Clay Whitaker is handling Hanson Melvin's claims in circuit court, demanding $500,000. Now, at Nooganomics.com this morning, you can read a little bit more of the details of uses of such words as F and M in reverse order, of course, spelled out to mean a very ungodly thing in the direction of incest. And he cites Grenda Harmer. What I like about Grenda Harmer is he's very much like a journalist. I see in his correspondence with me, copies of which I'm getting, correspondence with others that he has copied to me. I see someone who cares about process. I see someone who sees limited kind of safety in the rules. And he cites TDOC, that's the Tennessee Department of Corrections, policy 305.036A. that says employees shall conduct themselves in a professional manner when interacting with offenders. And then he also cites something that is really important, and that is the oath of office. Now, I bring that up, and I mentioned that in the headline today at Nooganomics.com because the oath is where the Constitution lives, right? The oath is where the law lives. The office holder, the officer, right? Officer and office holder, they're the same thing. They fill a duty. They bring a human heart and a human mind to a particular job or duty in the government, in the civil government. There's officer, a court officer, a judge, an official, a commissioner, council member. These are all people who take oaths to God, to obey the law and uphold the rights of the people. And we have to understand that law enforcement just has it backwards. It thinks it sees its job as assuming everybody is guilty. We just have to keep our eye on you, so that when you cross the line or make that turn without using your left hand indicator, that you are going to be stopped and you're going to be arrested. Well, we're going to arrest you and play the game, the police state game, without actually having to book you and to handcuff you or anything. We'll play this game of sort of pseudo policing, pseudo justice through the plea bargain system. But here in the prison, Corporal York had an oath as Grenda Harmer, the prison inmate, the troublemaking prison inmate, right? The man who asked the wrong questions, it seems, citing the oath that York took to, quote, fully, faithfully, impartially, and diligently, not only to execute the laws and regulations prescribed for the government of MCCX, which of course is Morgan County Correctional Complex, but that he will on no occasion ill-treat or abuse any convict under his care. That's the way Grenda Harmer writes the sentence. It's a very fine sentence with quotes in and out and putting all the stringing the quotes together in the rules that apply in one paragraph, citing the grievance. Right? The grievance is that the rule is dishonored by a man named Corporal York in Morgan County, Wartburg, Tennessee, in the state slave system that has 29,000 people enslaved, many of them producing no value and just waiting around. They're just waiting as the state destroys their lives and does nothing, absolutely nothing, for the victims of their crimes, right? The state does not care about the victim. It cares only about its own hallowed integrity, its own hallowed peace, its own hallowed equanimity, its own hallowed justice, and does not care about the victims of murder, the victims of rape, theft, robbery. They are not to be worried about, except in token, you can have a victim's session with the perpetrator. That's about as far as it goes, and no more. And so at Nooganomics.com, this inmate Grenda Harmer asks that Tony Parker, the commissioner, order Warden Sean Phillips to require all the employees to cease using profanity. Of course, in profanity, the greatest form of profanity, the most notable, is when God's name is used in vain. That is the worst kind. That because God's name cannot be used abusively. You cannot speak God's name without reverence, right? That's why the third commandment, "Thou shalt not take thy name in vain," is so important, because God wants his name to be revered and not lightly spoken of, nor his attributes, right? Nor his powers, nor his institution, the church, nor anything that touches as part of the creation. So marriage, if we talk about marriage, it should always be respectfully. It should never be lightly, as the comedians do. I think that's very damaging. Marriage should only be referred to in a hallowed and reverential way, because God made it, right? God made it as a picture of his salvation of the church, right? In marriage, the man chooses the woman and dies for her. That is what marriage is all about. Marriage is where a man chooses her and saves her, and he's the head, right? He's the head, she's the heart. She produces the children, he can't. She produces the children, and so she looks inwardly to the family life, to the next generation, to the home. He looks to conquest and business, warfare, service. That's generally how humankind works, and especially when there's the influence of Christianity, that is the model. That is the result of this understanding of creation. So God's name can't be used vainly, and especially not in profanity, especially when mixed with other abusive words by the guard, such as Corporal York, as mentioned here in this letter to the commissioner, accusing this corporal of profanity, to threaten and intimidate this inmate, Grenda Harmer. The name, I'm not sure where the name comes from. It sounds like it's from a Robert Penn Warren novel, or maybe a Flannery O'Connor story, maybe a story or a novel by William Faulkner. Well, this is David Tulis, and give me a call at 800-8949, 800-8949. Glad to hear from you. 800-8949. There's a story that I think touches on these questions. We've been looking today at courts and abuses in courts, and I think we should see the main picture. And I think I've gotten to see some of the main picture by covering the story of Hanson Melvin. And in his case, if you read about, you can't read about it anywhere but Nooganomics.com, the site for the man who matters, in which we do deep analysis of the court system as he went through it. And we can say in a nutshell the following sketch. Okay, this next minute here, if you have just a minute, it'll take just about maybe two. You can hear half of it. The problem that we have in the court, because we have courts that don't scrupulously respect constitutional rights, and we have courts that are lower, they're called corporation courts, that's Sessions Court and City Courts. Because we have these two lower courts, we have policing in high gear. Now, policing in high gear is possible only when you have a relief valve, and the relief valve is the corporation court. That is to say, these city courts and Sessions courts where hundreds of defendants are herded, and as we read from the American Bar Association and there's a court report system. Let's see, Courthouse News Service. Yeah, I'm looking at Courthouse News Service version of the story out of Nashville. ProPublica had a story about it last week that I was able to mention just briefly. And Courthouse News Service has the story again about the ABA, American Bar Association observers, finding that in Davidson County Sessions Court there is a mass abuse, and the mass abuse occurs because defendants are not made to understand their rights. Right? They don't know their rights to begin with. Thanks to public schools, we don't know anything about our rights. We don't know how to assert them. We don't know where they come from. We don't know how to defend them, or to be a belligerent claimant in person that you should learn how to be. Right? You, my listeners, should learn how to be a belligerent claimant in person. That is to say, someone who stands up for your rights. And your children should be taught that too, right? But we live in a public school era, and so there's nowhere to find that out from there, right? That place, and the inmates there, the leisure class on the payroll there, they're not going to teach your children that. You have to find out the hard way. And your son, only when he's 45 years old, will suddenly realize, well, he has a way of defending himself. He doesn't just have to be rolled over upon by the machine. But my 2 minutes are almost up, so let me finish. Because we have these corporation courts that relieve the pressure of policing, we have high policing. If we did not have corporation courts where people can sign themselves in, where people who sign the ticket can have their case heard there without being arrested, because people are not arrested, but they're cited, we have the volume that's possible. If people had to be arrested, you would find that policing would cut back almost to nothing, but that very few people would be charged at all. Very few people will be arrested, because police know that if they stop someone and arrest someone, they have to go through with it. That is to say, take that person to the jail, have that person first to the magistrate. You have to go to the magistrate first. Otherwise, it's kidnapping. To the magistrate, who views the charge and sets the bond, right? If you don't have that, if you go to the jail first, then that's called kidnapping. It's not allowed in Tennessee. No kidnapping allowed. You have to go to the magistrate. The magistrate has to pass on the judgment of the officer. And it's kind of like a pretrial hearing, right? Pretrial before the pretrial hearing, which is Sessions or City Court. And there you have this first encounter with the actual representative of the law. The magistrate's there 24/7, right? He's there always to pass on the judgment of the officer. Well, the story that we have in a nutshell, to finish, because we have these relief valve of corporation courts, we have policing in high gear. And policing in high gear, if it's a problem, okay, let's just assume it's a problem, but maybe you think it's not. If it's a problem, then that problem is solved by cutting off the inflow, which is to say, the inflow, the relief to the high inflow is the corporation court. And because we have these two systems working together, mass policing and corporation courts, where defendants are herded in and herded out, and everybody's told to strike a plea deal, you have a system which runs and blights the records of thousands and thousands of people in Hamilton County who didn't know they had a right to a trial. Right? You don't have to have that court handle your case. You can wait for an indictment, and that's why Hanson Melvin was different from many other defendants, especially in the world of black people. Black people just think, well, I'm in city court or sessions court. There's nothing else I can do but just plead, because I can't afford to miss work. I'm going to get fired. And that's why people strike plea. In fact, people strike plea deals for things of which they're not guilty simply because they can't afford to miss work again. Okay, so they plead, blighting their records once again, and not doing what Hanson did, which is to say, I demand my rights to be indicted. And that required David Campbell, the officer, to tell his story twice. A story which is reportedly not true. It's not true, and got him fired. But that's perjury, right? That's misdemeanor perjury and felony perjury. The fact that Hanson asked to be indicted required the officer to perjure himself in a felonious fashion. Right? The first one on the report was misdemeanor perjury. False police reports are just minor crimes, the punishment of which is no more than 365 days. Do it before a panel, a tribunal, such as a grand jury. That's felony perjury. So Campbell had to do it twice, thanks to Hanson Melvin standing his ground, and he did. But of course, Neil Pinkston, the district attorney, overlooks it. Neil Pinkston did not mind that the officer of the law lied. He did not mind that, and it was not a crime, and it's going to be overlooked. That is something. When you extend yourself the grace to choose which prosecutor you want to have, you might want to remember. And Neil Pinkston, who's elected to the office, can maybe be held to account by someone like you asking him the question, well, what about Hanson Melvin? What about officers who lie on the report and lie before the grand jury? In Nashville, according to courthousenews.com, a coercive atmosphere pervades Court 1A. That's because prosecutors push for plea deals and judges don't take the time to ensure defendants receive proper counsel and can pay fines leveled against them, the report found. One woman the court watchers met was in the court for the 5th time in 2 years. She was caught driving on a suspended license, but with 2 jobs that scraped in $1,200 a month to provide for 3 children and a disabled grandmother, there was little left to pay the fines to get her license back. Volunteers with the Arch City Defenders, a legal defense group out of St. Louis, Missouri, visited the court at the behest of the ABA's section on civil rights and social justice on September the 12th, 2016. So a year ago, this happened. The trip to Nashville was the launch of a major project to find violations of constitutional violations in misdemeanor courts across the country. Norman Lefstein is the main author, said the lack of counsel in some of the nation's lowest courts is a vast problem that has gone on for years. What about here in Chattanooga? 2 years ago, when the U.S. Senate held a hearing on the issue, Chairman of the Senate Judiciary Committee, Senator Chuck Grassley, an Iowa Republican, declared the Supreme Court's Sixth Amendment decisions regarding misdemeanor defendants are violated thousands of times every day. No Supreme Court decisions in our history have been violated so widely, so frequently, and for so long. In Nashville, prosecutors negotiated with defendants who were representing themselves and not completely aware of what is at stake, according to the report. Judges allegedly did not verify that defendants truly waived their rights to counsel and never determined if defendants could pay the fines that the courts levied. People scheduled to appear for court were booked, fingerprinted, and photographed in one room and shuffled into the courtroom where a prosecutor addressed the group, asking them if they wanted to strike a deal. And that is simply wrong. Now, the reason it's done that way is because before, in Nashville, there was a different system. You had to go first to one place outside of town to have that done, and then you had to go to court. So to make it convenient, it was all happening in the same place. The system now being described so negatively was brought about. When Courthouse News contacted the office of Nashville's District Attorney General, spokeswoman Dorinda Carter said in an email, "I can tell you that the report is factually inaccurate. Defendants in courtroom 1A are notified of their constitutional right to an attorney on at least 3 occasions." This report wonders about Tennessee Rule 1.1. In both courts, 1A and 3A, observers witnessed the failure of Nashville's judges to inform defendants adequately of their right to a lawyer and to determine if defendants' waivers of counsel are knowing, voluntary, and intelligent, the ABA study said. As a result, it is doubtful that the judges' conduct can be reconciled with Tennessee's Code of Judicial Conduct, which requires that Rule 1.1 that, quote, a judge shall comply with the law. So in the old system, there were 50 people a day. Now in Nashville, it's 200 a day. Very high volume. We have volume like that in Tennessee, here in Chattanooga, Tennessee as well. Well, Carol Gaddy is in jail in Sequatchie County, and she is a victim of abuse of process. That is what's happening to her. She's there at the behest of Mayor Dwayne Land, who, as we report, initiated litigation against Thomas and Carol Gaddy 2 years ago without exhausting administrative remedies, without even sending that couple of letters saying the commission would like to meet with you about what we believe are problems in your house. A house that has been given a 100% fine bill of health by an engineer who in July gave a detailed inspection and put his stamp, his licensed stamp on a letter saying that there's absolutely nothing wrong with the Gaddy house in Sequatchie County, but the problem in Dunlap. But the problem is that there's human will here and human pride that forbid any kind of recourse to the law, or for now at least, recognition that the law forbids arbitrary and capricious actions against private parties. It seems to me that Mayor Land and even the judge, Circuit Court Judge Thomas Rusty Graham, are acting without subject matter jurisdiction. Though we have to understand this, that if you're a judge in Tennessee, you have what's called effectively sovereign immunity. You can do whatever you want. Whatever you want. You are immune because you're acting in your official capacity. And your private parts are not showing in any way, and therefore you're not personally vulnerable to abuse of process. So it seems that while there's a whole body of law that discusses judicial immunity, there are other parts that imply that there is recourse against a person, but there has to be a showing in the process that this person was acting in bad faith as a judge. It's very hard to do, and I'm not sure that the Carol Gaddy case, which fills 2 large folders in the Chancery Court office there, has done that, though she has complained in many motions that she's being abused by Dunlap. Is that a place in which you'd want to invest your money or buy land? David Tulis here. I'm not sure about that. Now I've got some important messages.
The Tennessee Valley's news, talk, and sports leader, Nooga Radio.